So today we're going to talk about risk assessments, compliance, transparency, regulatory frameworks, but I thought I'd focus a little bit about what our team focuses on specifically. We do three things generally. We work with the sales organization to help determine what the gaps are when it comes to regulatory compliance concerns from our customers. What are the gaps? What are the biggest hurdles for them? And the second thing we do is we drive programs internally at Google Cloud to help address those regulatory compliance gaps. Now, we can't address gaps in every vertical in every country in the world, but we do address gaps that are the biggest priority for our customers and for Google. And then the third thing we do is, if there are gaps that we've identified in the market from a compliance perspective, and we have difficulty in closing those gaps, we will often work directly with regulatory authorities in conjunction with our legal and public policy teams to help discuss with them how the law is being enforced, to see if there's a way that we could have the regulation enforced in a way that would facilitate cloud adoption. And the usual disclaimer, this is not legal advice. Please talk to your own counsel. But I'm hoping this does provide you with some very helpful information. So the reason why folks are here, data protection and regulatory compliance is certainly top of mind, and we're here to help. There are a lot of open questions that people may have. What are best practices out there? I mean, the cloud is becoming a very well-developed industry, but there are still a lot of new aspects to it. What about reconciling differences among different regulatory authorities or different jurisdictions? What about the shared responsibility model? What is Google responsible for as the cloud provider for your services versus what the customer is responsible for when utilizing or otherwise provisioning the services? How to avoid non-compliance? What are the best security controls to implement? And how to make sure that data isn't being inappropriately used by your cloud provider or accessed by your cloud provider. So these are big concerns that people have. So in following with that, there are four areas that I want to focus on this afternoon. I want to talk about shared responsibility. That's a big one. Compliance assessments and shared responsibility. What is the Google Cloud what is Google Cloud responsible for as the cloud provider, and what should the customer be responsible for as the person utilizing the services? The importance of transparency and being able to conduct a meaningful risk assessment of your cloud provider services. And then the importance of contractual commitments. How are those coming into play, and how do regulators leverage the contracts that you have with your cloud provider when they conduct a regulatory assessment? And finally, we're going to talk about some of the more recent regulatory frameworks that have come to pass and things that we're looking at regarding updates. So let's focus first on shared responsibility. Now, as I mentioned, we have lots of customers. In fact, we have customers in most countries of the world in virtually every vertical. And when you think about major verticals, healthcare, government, education, manufacturing, retailing, privacy considerations, we have customers in verticals globally. And when you consider how many countries that we have customers in and how many verticals there could be hundreds of thousands, if not millions, of potential regulatory frameworks. So we're not going to stand here and give you an overview of 1 million frameworks. I don't even know anywhere close to something like that. So what's important when it comes to assessments of regulatory obligations to leverage what you know and then leverage what we know. For example, you have experience in your industry. You typically will know what existing regulatory frameworks would apply to you and your business that you've been following for many, many years. You know what your country priorities are. You know what verticals you're working in. You may already have counsel that you're working in that can provide you guidance. On the other hand, Google, as your cloud provider, we know the cloud. We have experience working with regulatory authorities when it comes to focusing cloud initiatives. Remember what I just mentioned? And we also have technical expertise regarding our services. So at the end of the day, our obligation is to be able to provide you with transparency about our services so that you can conduct a meaningful risk assessment of your cloud provider before you choose to deploy them. And that's key, the meaningful risk assessment. And speaking of meaningful risk assessment, there are a number of questions, based on what we've done over the past several years in working in regulated markets, that regulators may expect you to ask. As I mentioned, we work with regulators all over the world, and one thing is common. They expect you to conduct your due diligence. In other words, answers to these questions. These questions come up all the time. How is your cloud provider protecting your data? Or how are you leveraging the security controls provided by your cloud provider to protect that data? Who owns the data or the IP that's uploaded into the cloud? If you upload your content, your data into Google Cloud, does Google suddenly own it? The regulator wants to know the answer to that question. And I'll give you a preview. No, we do not own the data that you upload into the cloud. But the regulators expect you to ask that question and know the answer. How is data being used? How do you know that the data you're uploading into Google Cloud is not being used for advertising purposes? And by the way, we don't use the data you upload into the cloud for Google Cloud for advertising purposes. But again, you need to know where to find that information and demonstrate it to the regulator. What if there's a data incident? How can you be notified? How will you be notified? In many jurisdictions around the world, if there's a data incident, just because you're storing your data in the cloud doesn't mean you have no responsibility in notifying your users or your customers or clients. So you need to know when will you be notified and how will you be notified. Data deletion. If you delete something from the cloud, how do you know it's actually gone? How do you know it's just not sitting around forever? Regulators ask that question as well, so you need to know that. Data portability. Let's say you get tired of your cloud provider. You want to take your data and you want to move it to a different provider, or you want to store it offline or do whatever you want. It's your data. What are those capabilities? What type of data will be stored? Regulators are often focused on a particular vertical or data set. So for example, data protection authorities in Europe may be focused on personal data. Sometimes we call it PII in other jurisdictions. Or financial regulatory authorities may be concerned about financial transactional information. So you want to take an assessment of the data that you're processing and will be using the cloud to store to determine what regulatory frameworks would apply. Where is it stored? Many regulatory authorities, at a minimum, want you to know where the data is going to be stored for risk assessment purposes. Some frameworks may actually require data location specifically, but at least transparency. And then finally, third-party audits. How do you know what your cloud provider is telling you is actually true? So these are the kind of questions that regulatory authorities, and others, by the way, are expecting you to ask. So our job, when it comes to questions like these, is to provide you with transparency that you need so that you can demonstrate to your regulator that you've conducted your due diligence in answering these types of questions and others. This is a preview. And speaking of security and shared responsibility, security is shared between your cloud provider and you. And the relationship between what the cloud provider typically will be handling as part of that responsibility versus the customer will often depend on the type of services that you're utilizing from your cloud provider. And this requires collaboration between your cloud provider and yourselves and the customers. Now look, this graphic is not definitive, but it's just an example where the graphic represents that the provider, in this case Google Cloud, for example, would be responsible for the yellow area, and the blue would be the customer's responsibility. So if you look at this example, Google generally, and this is very generally, is responsible for securing the infrastructure. And the customers are responsible for securing the data that they place into the system, as well as who they want to have access to that data. So access and data. And the responsibilities change based on the type of service you're using. For example, if you're using software as a service, where Google is providing something like G Suite, for example, we're providing the software, and you're simply placing your data into that system and allowing your users to do that, then we're responsible for a good majority of that versus the IT department of the customer. So for example, for G Suite, content or access, which users have access, and the usage policies, that generally will fall on the customer, but anything from the software down is responsibility of Google Cloud. But if you look at something like platform as a service like App Engine, then the responsibilities are a little bit different because we're providing a platform in that instance. And so there's more responsibility on the customer regarding what apps they choose to deploy on, for example, App Engine. And if you look at GCP, which is the abbreviation for Google Cloud Platform, you'll hear me reference that later, that's infrastructure as a service. We're providing the infrastructure, and so we are generally handling the areas near the bottom, like network and storage encryption, hardened kernel and boot and hardware. But everything else, you're deploying the applications and machines that are being utilized in infrastructure as a service. So knowing that division of responsibilities is very important from a compliance perspective. The other thing I wanted to highlight with respect to this, there are many areas of responsibility, as I mentioned. From the security perspective, and again, it's a sliding scale, there's infrastructure security, network security, data security, and application security. And the responsibilities may change, as I mentioned, depending on what type of service you may choose to deploy. And then something which is almost certainly always a customer responsibility would be identity and access management, determining which of your users should have access to these services. Who gets accounts, for example? And then securing endpoints. What computers are you choosing to allow your users to use when they access the services? Are they allowed to use mobile devices? And if so, what should be the security policies? So the goal here is to provide capabilities across all of Google Cloud, GCP, G Suite, and connected devices that cover the whole stack. And that also involves specific security controls as well. So we want to provide capabilities and assistance across our services that cover the entire scope of these potential responsibilities. And with respect to this, we will also do things like provide help, like best practices, documentation to help support this, templates, and of course, products and solutions to address this shared responsibility model. And we have lots of collateral on this that you can reference. So everything that I've been telling you about our security capabilities, our data protection capabilities, when we say we don't use customer data to serve ads, or we don't use it for our own purposes, and that we protect your data, and we're responsible for this, and you're responsible for that. That's certainly important, but being able to conduct that assessment requires transparency. And in fact, everything that I could be telling you about our security capabilities could be lies. How do you know that I'm not lying to you right now? Your regulator expects you to know whether or not your cloud provider is telling you the truth. They expect you to conduct your due diligence, as I mentioned, to verify what we're saying is true. And a great way to be able to do that is to leverage third-party audits and certifications. And what this means is that we invite independent third-party auditors to come in and evaluate our affirmations regarding data protection, security, privacy. We have hundreds of controls that we'll talk about on the next slide that describe what our security practices are, from authentication, our own internal systems, network security, encryption, data use restrictions, data deletion, access management, background investigations. These controls, therefore, are verified by these third-party auditors that come in. And I want to highlight a few things in particular. One very useful aspect for due diligence purposes, because remember, we're talking about due diligence and what regulators expect. One very useful aspect of this is the SOC 2 report, as you can see here on the left. The SOC 2 report is a report that's generated by the auditors when they come in and evaluate our controls. The result of that audit is a very detailed and quite confidential report that describes our security controls and our data protection capabilities. And the use of the SOC 2 report is, what you would do is you would obtain that report, and then you would assess it in comparison to what your existing security requirements are. And they might be quite specific if you're in a regulated industry. The goal then is to review the two documents. And the SOC 2 report is several hundred pages, a couple hundred pages, I think. and quite detailed. The idea is to review the documentation and look for any differences between the security capabilities that we would be providing in Google Cloud, for example, and what your own requirements would be in your industry or vertical. And that gap assessment is therefore what you would focus on when it comes to what would be remediated in terms of cloud deployment. So that's the SOC 2 report, a detailed NDA report regarding our security capabilities. Now, the SOC 2 report is very useful because it's detailed, but it isn't in and of itself a security standard. There's no one that said, if Google does all these controls, suddenly you've attained a security or data protection standard. We're audited against an auditing standard, but it's not a security standard. And that's why a few years after we adopted SOC 2, we also adopted ISO 27001. And for people who don't know, ISO 27001 is an IT security standard. It's developed by the International Organization for Standardization. Representatives from virtually every country in the world come together and they create these standards. And the standards are in all sorts of verticals. They could do with manufacturing or housing or glass, but there's one involving IT. And they are the ones who write the security controls. They are the ones who come up with the controls. And then we are audited against ISO's controls. Therefore, if you achieve those controls, if your internal capabilities align with ISO 27001 requirements, then you receive a certification, like a diploma, from a third party. And that shows you've attained a certain level of security or data protection. The reason why we choose something international like ISO is because it increases the likelihood of its utility to customers in a global perspective. It also increases the likelihood of its acceptance by regulatory authorities around the world, because most likely regulators in that same country will have an agency or a same country representative to ISO who is involved in the standards creation process. So they have a voice already. It's not going to be the same regulator. It's usually a different representative. But each country typically has a voice for ISO in the creation of these controls or standards. The other two ISO certifications I want to point out, or controls I should say, is ISO 27017 and 18. ISO 27001 is an IT security standard, but it was created many years ago before the prevalence of cloud computing. More recently, ISO came out with additional controls that are focused specifically on cloud. They came out with new controls for cloud security, which is ISO 27018, and cloud privacy data protection, which is ISO 27018. And the nice thing about standards and these certifications is it allows for better understanding of the services. It allows for better transparency with regards to what the actual practices are. And it demonstrates to regulators, if you review them, review the audit reports and the certifications, that you've done work regarding your due diligence. Now, the ISO controls, by the way, are not things that the cloud providers can hand out. You actually have to buy the controls themselves from ISO as part of your due diligence assessment. So you buy the controls, and then you review them against the SOC 2 report and your own requirements, and that adds yet another layer of data protection capabilities and data protection readiness. Now, everything here that's listed are not third-party audits, but they are also regulatory frameworks that we have chosen to follow when it comes to the provisioning of services globally. So, for example, in the US, we offer business associates agreements for customers that are regulated by HIPAA if they're dealing with healthcare or patient information. Something else that we've noted is FedRAMP. We've had FedRAMP Moderate, where we can provide services to US government agencies. And we've maintained moderate impact level. And one thing I should note is that we are in the process of obtaining authorization for FedRAMP High Impact for 66 of our Google Cloud Platform products. We've already undergone third-party audit for FedRAMP High and submitted the required documentation to the government. So you'll see industry-specific regulatory frameworks that we need to follow, and so we will adopt them based on customer need. So HIPAA is one, FedRAMP is one, Down at the bottom, SEC 17A4 has to do with providing services to broker-dealers. In Germany, we obtained BSI C5. In Australia, last year, we obtained IRAP, which allows us to provide services to Australian government agencies. Of course, you see GDPR mentioned. I'll mention that soon. But there are other frameworks as well, like MTCS in Singapore, or the Australian privacy principles, or looking at guidance issued by the Australian Prudential Regulatory Authority for Financial Services. So we try to leverage international certifications whenever possible, but of course we will also obtain region or country-specific as necessary based on customers' requirements. Now, you heard me mention controls. Controls that are reviewed during our SOC 2 audit, controls that are mandated by ISO 27001, 17, and 18. There are lots and lots of controls, probably way more than what I've indicated here, but this is just an example of the areas that auditors are looking at, and this is exactly why you want to leverage this as part of your due diligence. Areas like information security and privacy compliance and business continuity. What if there's a disaster? Remember I mentioned incident management? How do you know that there's a process in case there's a data incident or a data leak? How do you notify your own users if you're not notified by the cloud provider? Incident management is also listed. What else? Cryptography, encryption, communication security, operational security, restrictions on data processing. You see purpose and scope of processing. This is where we're audited against the requirement that data is only processed or used for a particular purpose, not for Google's own purposes or for advertising or for use for Google's own purposes like a competing product or what have you. It's all very, very important. Sub-processor disclosure. What if Google uses vendors? Who are the vendors? How are you supposed to evaluate them? So these are examples of the controls that are audited when we talk about third-party audits and certifications. But due diligence does not have to stop there. We also create white papers and have online resources that you can leverage to learn more about our services and our products as part of that risk assessment and due diligence process. Since GDPR launched last year, we released a data protection implementation guide, information on how to best provision, in this case G Suite, with respect to data processing obligations that may fall upon the users of Google Cloud, how to restrict certain services to help make sure the data is not otherwise being used contrary to those requirements. A paper on data deletion in Google Cloud Platform. Remember we talked about how do you know that when you delete data, it's actually deleted? What if regulators ask? And I guarantee you that many people who use the cloud don't even think about that. But you should. And here's where you can find more information. Security white papers. We also have, of course, technical documentation and much more thorough information regarding the utilization of the services as well. You can also go on our website and look up standards and regulations and certification to get more detailed information about some of the frameworks that we've covered earlier. Now, we talked about data centers and where data is, transparency regarding potential locations for your data. You need to be able to know about Google's data center infrastructure. And speaking of infrastructure, what sort of factors do we look into when it comes to choosing a particular site? Now, I should say that many of our services utilize many different data centers for business continuity and geographical redundancy purposes. Some services also allow you to choose a specific data center, if you'd like. Excuse me, it depends on the services. But the factors that we might consider when it comes to data center selection, site selection. Why does Google choose to open a data center in one country versus another? Now, people might think, as part of the due diligence process, people might think, oh, it's because you do it because there's great bandwidth, or you have a lot of users in that area that aren't served by local infrastructure. But there are also other factors that we consider when it comes to site selection, besides bandwidth and cost. What about policy? We don't want to have a data center in a country that does not have a stable government or a rule of law. If there's no functioning court system, then how are we supposed to be able to defend our interests and those of our customers when we have a data center in country? So we need a rule of law. We need a functioning court system. Content is something else that we consider. We don't want to build a data center in a country where we would directly, as Google, be liable for all the content that people would post on our systems. We need to have a mechanism to be protected from that and to protect the interests of our users. Trade. You won't see us building a data center as a US company in countries where it's unlawful for us to do so. So you won't be seeing data centers in OFAC-restricted countries like North Korea and Sudan and Syria and Cuba and the like. So that's another consideration. So the fact that data centers are deployed where they are is not by chance, and it's not just based on cost. So we talked about shared responsibility and compliance assessments. We talked about the importance of transparency, verifying what we're saying about our services is actually true, so you can make that demonstration to your regulators. Now let's talk about contractual commitments. Oh, there's one example I want to provide, regarding transparency. A real life example. A few years ago, a school system in Northern Europe, in the Nordics, they were contacted by their data protection authority in Europe. And their question to them was, you're using G Suite for your school system, for your students. How do you know that Google is not using the student data for advertising purposes? How do you know they're not using their personal data for ads? Now, how would a school respond to that? The way they would respond to it, and the way they did respond to it, was by referencing the appropriate controls that were surfaced during, for example, the ISO 27018 audit. The ISO controls that focus on data protection. Remember there was a control that talked about scope of processing and data restriction? That's the control they referenced. They used that to respond to the regulator inquiry, and that helped resolve it. Third-party audited control. So yes, it's super important. I don't want people to underestimate the importance of reviewing these audits and certifications as part of their assessment. It can help when proactively engaging with regulators, and it could help if you get a regulatory inquiry. I have seen customers get in trouble for not doing any due diligence. If a regulator asks, why are you using this cloud provider or that one or this one, the answer should not be because they're really good. The answer should be because I conducted an assessment based on our third-party audits and controls, and it doesn't have to be Google Cloud. It could be any provider. This is baseline. So, to continue, contractual commitments. Why are contractual commitments important? Like I said, transparency is critical to verify what we're saying is true, but it doesn't really matter if nothing's in writing. What's going to obligate us to continue to do these third-party audits and maintain these certifications if it's not in writing? And there have been many cases where regulatory authorities have asked to see the contracts between the cloud customer and the cloud provider. And by the way, there could be a question regarding, are you in a regulated industry? Things to think about. You may already know this because you've been doing this for a long time for your own business, but regulated industries could concern education, for example, or student records, or financial services, or government, or specific data elements in any of those areas. Or if you're dealing, even if you don't think you're working in a regulated industry, you may be dealing with regulated data, like personal data of European users, for example, that could be covered under GDPR. So even if you're not in a highly regulated industry, these are still very helpful and useful best practices for your own edification and for your own diligence. So I mentioned that I've seen regulators, particularly financial services regulators, ask for contracts between the customer and the cloud provider. So the regulators want to ensure that the contracts have the protections that are required to ensure the cloud provider is doing what they're supposed to be doing, and to ensure that the customer, let's say a bank, is sufficiently protecting the interests of their clients, their customers, and their users when using a cloud provider. So, what sort of things are we looking for when it comes to contracts with your cloud provider? And I'm not going to give a whole treatise about contracts because that's super boring and you don't want to hear it and I don't want to do it. But very quickly, there are basically three areas when it comes to the contracts that you may see with Google Cloud. We have the fundamental baseline customer agreement. And that's where you may find things like commercial terms, billing, how much does it cost? What sort of technical support do you get based on the service that you're obtaining? Who owns the IP of the data that you're putting into the systems? And again, remember I said Google does not claim ownership of the content that you're providing in our systems. But then something that's really important for our discussion are the data processing terms. And we have these both for Google Cloud Platform and for G Suite. And we're gonna focus on that in the next slide, but at a very high level, these are where we have the privacy commitments. This is where we have the data use restrictions. Remember we talked about that control regarding limiting the scope of processing? This is where we maintain our obligation to have these repeated third-party audits and certifications. As you don't want them ending the minute you sign up for a service, right? So there has to be an obligation to keep doing them annually or biannually or what have you. Obligations for things like data deletion. When you delete data, when will it go away and in how long? And then finally, we have region or industry-specific terms, like EU model contract clauses, which is specific to Europe. So if you have European users, but you're storing Google data in Google's global infrastructure, you need a mechanism to export personal data. So that's what EU model clauses are for. You heard me mention business associates agreements, which is important for HIPAA compliance for our customers, where we obligate ourselves to certain commitments to serve customers that have HIPAA obligations. FSI audit clauses, we'll talk about that later as well, but banks require special clauses that their regulators would otherwise mandate. And of course, there's special language regarding industry-specific requirements like FedRAMP, which you heard me talk about a little bit earlier. So that's generally the contract structure, but let's focus in on the data processing terms. This is really, I think, one of the main focus areas of this discussion. And this is where the written legal obligations are set forth so that you know we are committing ourselves as a cloud provider to these obligations. So for example, this is where we promise that data will not be used for any other purpose, for example, than to process the data per your instructions, to provide the services, and not using customer data for ads. Because people may typically confuse consumer services like search with business services like Google Cloud, which are completely different. This is where we include an obligation that when you delete your data, it will be purged within a specific period of time. The data will no longer exist. And I would posit that in many cases, this is different than what people would do with data on site. I don't know a lot of companies that have on-site data centers that will actually purge the empty space on their servers necessarily. This is where we maintain the obligation, or we include the obligation to maintain these audit reports and certifications that you've heard me talk about so much. This is where we say, we will do this, we will not end it. Every year, you will have it, it will be refreshed, you can access it, what have you. Same thing with certifications. Sub-processors. You heard me talk about, what if Google uses vendors? How do we know that Google isn't outsourcing all of their data processing capabilities and sharing all of my personal data or financial services data with third parties? I can tell you that as Google Cloud, obviously we do the vast majority of data processing ourselves. That's why people use Google, and we use ourselves as well. But there could be services that we outsource, like technical support, or customer support, or 24/7 coverage, or different languages. But if that is the case, then again, regulators expect you to know who these sub-processors are, vendors, if you will, and in many cases obligate you to be notified if there's ever going to be a change to them. So in these data processing terms, we provide a link to an externally facing page where we list all of the vendors that we might use for these purposes, where they're based, and then an obligation to notify our customers if there's going to be a change so that customers have an opportunity, for example, to terminate the contract. Security measures. We include an obligation to make sure that we protect the data. This is where we include an obligation to provide you notice in case there's a data incident. Because as I mentioned, you may have your own regulatory compliance obligations with regards to notifying users of a data incident. And it's unlikely, but if it ever happens, you need to know yourself so that you can comply with your own obligation. So that's where we include that, for example. From a privacy perspective, we also include pointers to a data privacy officer, someone that you can contact through the contract if you have questions from a privacy perspective. So this is why the data processing terms are so important for Google Cloud, particularly GCP, Google Cloud Platform, and G Suite. So we talked about shared responsibility, transparency and control, the importance of contracts, where the written obligations are, and that regulators sometimes want to see them. Finally, let's talk about some of the more recent regulatory changes and things that are top of mind for us right now. Let's talk about regulated markets and the themes that we've seen, particularly when it comes to specific frameworks. As I mentioned, regulators want to see the type of data that's stored. They want to ensure that customers in regulated markets, and let's use financial services as an example, banking regulators or securities regulators. They want to ensure that if a securities firm or a bank moves to the cloud, that the customers can maintain the same type of oversight over their cloud provider as they could hosting the data on-prem, right? That means customers need to be able to have audit capabilities of their cloud provider. You've heard me talk about how third-party audits and certifications are so important from a diligence perspective. In highly regulated markets such as banking, regulators may demand that customers have a direct audit right over their provider. And so in those markets, we do provide that. Now, of course, it's very difficult from a scalability perspective. If 1/100th of 1% of all our customers chose an audit, we'd have 10,000 audits being initiated every day. So we strongly encourage the use of third-party audit reports, but we do provide that capability. The other thing that's important for many regulators we've seen in financial services, as an example, is the importance to them to make sure that their oversight capabilities over the customer do not change if the customer moves to the cloud. Because regulators right now, they expect the ability to be able to audit their licensee, their bank, anytime they want, any place, they audit their license, they're just going to do it. So we often have concerns from regulators that if a customer moves to the cloud, how is that capability maintained? And we mentioned to regulators, and we also have this in special regulatory terms. Remember, I mentioned regulation-specific or industry-specific terms. We include language that says just because the customer moves to the cloud doesn't mean that they've changed their reporting requirements to their regulators. We acknowledge that they are still within the jurisdiction of that regulatory authority. And it's important for customers to demonstrate to their regulators that banks still have that similar oversight capability. We actually have language that provides customers with the right, should they so choose, to share the data directly with the regulatory authorities if they want to as the customer. And we are just the provider. It's between them and their regulator. So we want to ensure that customers can have oversight over us. We allow the regulators to audit us if necessary. They can have oversight over us. And then the important thing for customers to do, besides demonstrating compliance with due diligence, is to help the regulators understand that their oversight does not change in the use of cloud. So that could include things like financial regulatory audit. It can include regulators or customers wanting to visit data centers as part of a direct audit. The point is that we have special considerations that are industry-specific to help address this, and a lot of this does involve regulators maintaining jurisdiction and direct audits. I can't have a talk about regulated markets without talking about GDPR. This is what passed several years ago and took effect May 25th of last year. And for people who have been under a rock, it's the most significant piece of data protection legislation that has been passed in a long time, 20 years. And the idea was to harmonize EU data protection law. Now, I know we are in the US, and this is a US discussion, but it's also a global discussion. GDPR could apply to any multinational organization that has users, customers, employees, students that are EU persons. And so that's why GDPR is still important for us to look at. For Google, it was more of a evolutionary process rather than revolutionary. And I'll talk about that more on the next slide. But the important thing here is that it aims to strengthen the rights of individual users in Europe with respect to their personal data. It focuses on personal data. And it harmonizes EU law. Prior to the data protection regulation, there was the Data Protection Directive of 1995. And that wasn't really a law in and of itself. The Directive of 95 basically instructed countries in Europe to pass their own laws. There was harmony, but not exactly. And so that's why the regulation has direct force of law, and that was the goal, one of the many goals. Excuse me. So from a Google perspective, there are a number of things that remained the same for us, things that changed and things that were new. And again, this is something that we pivoted to in May of last year. The core principles of the GDPR with respect to previous EU law, the Data Protection Directive, remain the same. Purposeful limitation. And again, when I say that, I talk about restricting the use of data or how data is processed to very specific purposes, only to the instructions of customers. That remains the same. Obligations to delete the data, to protect the data. The foundation for transferring data, personal data from Europe to the rest of the world, things like Privacy Shield and model contract clauses, those remain the same. But there are some things that are stricter or were new in GDPR, like stricter obligations for data processors. You haven't heard me use that term before, but using the EU construct, cloud providers are typically the data processors in the enterprise context. We process data according to the instructions of our customers. And our customers typically are the data controllers. They instruct us on how the data should be processed. Under previous EU law, the data processors, the cloud providers, were not directly liable to the regulators. It was the data controllers that were responsible. But that all changed under GDPR. Now the processors, the providers like Google, are directly responsible, in addition to the customers, for compliance with GDPR. So that's new. But what's not new in many cases for Google are things like incident notification. That's a new requirement in GDPR, but we've been doing that for many, many years because there were other laws that mandated it for quite a long time. And so we've already provided that in our contracts. Data portability, data return, that's a new GDPR obligation. But for folks that have been using our services, you'll probably know we've offered data portability capabilities also for many years. We enhanced them for GDPR, but they're not new. The right for data protection regulators and customers to audit us. We've again had that for many years based on regulatory guidance to facilitate adoption in Europe, but that's also new for GDPR. And of course, remember you heard me talk about the disclosure of vendors, sub-processors? That's a new requirement under GDPR, but again, it's something we've been doing for years based on regulatory guidance. But what is new, as I mentioned, is that it applies to data processors, cloud providers, as well as customers. There are much greater fines, up to 4% global turnover. That gets everyone's attention real fast. And of course, there are very specific contractual obligations. And our data processing terms have been updated for GDPR. The other thing I want to talk about is the California Consumer Privacy Act. How many people here have heard of that so far? Okay, that's good. So very quickly, regarding the CCPA, it takes effect in 2020, in January 2020. It was passed in 2018. It has good goals. The goals of the California Consumer Privacy Act is to improve transparency. You remember we've talked so much about transparency regarding the handling of personal data by companies. It talks about giving consumers more control over that data regarding the personal data that they may place into the system. It includes obligations to secure that personal data, things that we've talked about also, and it holds companies accountable. So in many cases, there are similarities to things like GDPR, and in that respect, we are leveraging a lot of our GDPR work for CCPA. They're not the same, but there are similarities that we can use with regards to the diligence that we've done over the last several years. It applies to businesses of all sizes who interact with people that are in California. So that's the nexus. There's a very strong California connection because it is a state law that is coming into effect. Now, with that said, the law was passed very quickly, and it may change over time. We don't know exactly what those changes will be. It's very far-reaching right now. It may change, it may improve. And we personally are assessing the law from an enterprise perspective and how it would apply to Google Cloud. And as I mentioned, we may very well leverage our GDPR work as things evolve. So it does take effect in 2020. It may change. There are things that we're watching closely, and as things develop, we'll have more to talk about. But that's generally where things are with the California Consumer Privacy Act. So you've heard me talk about working with regulatory authorities. It's very important for us as a cloud provider to seek clarity when there is not clarity when it comes to the regulation of companies that are utilizing cloud services. So we've worked very hard over the last few years to interact with regulatory authorities all over the world in key markets. Now, this is not endorsements, but these are examples of regulators that we have worked with to seek their feedback and hopefully incorporate that into our services. And the reasons why we work with regulators is, there are a number of reasons, actually. For example, some regulators, particularly in the earlier days, were not familiar with cloud computing, what it was. They were not quite clear about things like shared responsibility. They needed to learn more regarding cloud so that they could provide guidance to their users, to their licensees. So we work with them along with our public policy colleagues and legal colleagues to provide background about the cloud. And in many cases, regulatory authorities want deep dives from a cloud provider. They want to know, what is your incident response process? What is your business continuity process? What is your process for reviewing vendors when you choose a vendor to do customer support? How are you ensuring that you only limit their access to data to what is absolutely required, which, by the way, is what we do. So we give them that deep dive, that information they need to help that assessment. And in many cases, regulatory authorities will launch or publish cloud guidance, how you can leverage cloud systems for the financial services industry. And in order to issue that cloud guidance, they need to be able to obtain information from cloud providers about cloud architecture, how cloud works, pain points, and what have you. The other reason why we work directly with regulatory authorities is because we want their feedback for our contracts. For example, let's say a regulator in a particular jurisdiction says, your contract is bad because it doesn't give customers direct audit rights. So we say, all right, we'll put direct audit rights in the contract. We want to make sure we have direct oversight as the regulator regarding your IT systems. Okay, well, you can be provided with whatever information you like. And so the idea is we want their feedback for our contracts ahead of time to make sure that everything is taken care of before customers adopt the services. Now, that may not always be the case. There could be cases where we haven't engaged yet and we do it after the fact. But ideally, we want to do it ahead of time to make sure that cloud adoption is facilitated in each of those markets. And we do have lots of customers that we are fortunate to have at Google Cloud who are in highly regulated markets, and we work closely with respect to everything we've talked about here in this presentation. These are real, actual practices, and they're very important to deploy. So let's review what we talked about today. We talked about shared responsibility, the importance of conducting a compliance assessment and making sure that you have the information you need to conduct a meaningful risk assessment and determining what the shared responsibility model should be based on the services. We talked about transparency, making sure you have the data you need to conduct a meaningful risk assessment. That's critical, right, to demonstrate diligence. We talked about the importance of contractual commitments and making sure that the obligations are in writing in case you need to demonstrate that to a regulator. And we talked about evolving regulations and things that we're looking out for, such as GDPR and the California Consumer Privacy Act, and market-specific considerations like financial services. So ultimately, what we hope, and what I hope, is that you will consider partnering with Google to meet your regulatory compliance needs. Anything you need, you should be able to find. We'd certainly like to help you on our website as well. And I'd like to thank you for your time and your patience. And that's it for the presentation. One thing to add, if you can, please provide feedback. It's very valuable for us, and it would be very, very helpful. So thank you for your time. Bye-bye.